Clients ask, well, how long is my case going to take? And when I say it depends, it really does depend. That's not an easy way out. When an insurance company makes the first offer, that's really the beginning of the back and forth between the law firm, our law firm, and the insurance company. So what happens when negotiations pre-suit take place and a case cannot get resolved? Well, the next step is for us to file a lawsuit, and that takes the case to a whole different place. Once we're able to put together demand and send it to the insurance company, sometimes they don't want to be fair. They don't want to make a fair offer. They don't want to negotiate, I believe, in good faith, and they kind of want to play games. And we'll try our best to be patient and go back and forth and give them a chance. Hopefully the case can get resolved. Hopefully they finally offer something that's acceptable to our client. But the truth is there are instances where that just doesn't happen. And the next step is that we've got to file a lawsuit. In many cases, a lawsuit needs to be filed. Once we do that, then the lawsuit gets served, it gets delivered to the defendants in the case. Then the next step is for them to get counsel, get lawyers, and to file an answer. And so once the defendants file answers in the case, there's a certain period of time that passes, and then each side is required to start disclosing certain important information, such as what's called persons with knowledge of relevant facts, people who know something about the case, about the liability part of the case, about the damages part of the case, the identity of those people, their names, their addresses, their telephone numbers, that kind of thing. Also, any insurance policies that are pertinent to the case. And then also, say, authorizations for the other side to get medical records and bills. And that's a part of what needs to be disclosed by the parties in a case at the outset. So the next step is for the lawyers to exchange more formal discovery requests. And those are called interrogatories, which are questions that each side needs to answer. Requests for production of documents that each side needs to respond to. There also could be things like requests for admissions as well. Once responses to those items are provided, the next step is to start with depositions. A deposition is an opportunity for the lawyer to talk with a witness. It could be the defendant in the case, it could be eyewitnesses, it could be medical doctors, it could be experts. So it's an opportunity to talk with the witness under oath. And it's a question and answer session where the lawyer asks the questions that he or she needs to ask, and then the witness is required to answer those questions. And depositions are recorded, oftentimes just stenographically, which means the questions and answers are written up, and each side gets a copy at the end. And then many times the depositions are videotaped as well. And that's an essential part of the case that helps the parties to more fully discover the case, what happened, why it happened, and say what the value of the case is. So if you have any additional questions about your timeline, how long it takes, how long it can take for a personal injury claim, please don't hesitate to contact us at the Callahan Law Firm. And you can do that by going to our website, and that is www.thecallahanlawfirm.com, or you can call us at 713-224-9000, and we'll do everything we can to answer your questions to help you understand how long a case can take, because every case is different.